The Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Good morning, everyone. Please be seated. A lower chair than usual. I nearly went over on my feet there. Okay. Can you see me even? Wow. All right, now we're getting somewhere. Okay, we have 6 cases for argument this morning, so we have a full roster on the last day of the term. Accordingly, we'll be trying to adhere to the clock. That's what I'm telling you. Our first case for argument this morning is United States versus Swan, and it is docket 256032. Counsel, we're ready for your argument.
Good morning, Your Honor.
Good morning.
Sam Ballingood for Appellant John Miguel Swan. I'm going to endeavor to save 2 minutes of time for rebuttal. Your Honor, Mr. Swan is today halfway through a 10-year sentence which was imposed because he exercised his constitutional right to possess ammunition. Yet no court has seriously asked whether that sentence violates those rights. This case is not governed by this court's precedents in Vincent and McCain. Those cases concern firearms. Mr. Swan presents a legally and factually distinct question from what was before the court or decided in those cases. Applying the modern Second Amendment framework today, the government has failed in 2 basic ways to meet its burden to justify this sentence. First, the government has failed to do what this court in Harrison recognized that it must. To the extent that a modern disarmament law is based upon a legislative judgment about dangerousness, that judgment must be substantiated. Failing to apply this step leaves the Second Amendment subject only to rational basis review. A result we know cannot be corrected has been squarely rejected by the Supreme Court and this court. Second, the government has failed more broadly to establish a relevant historical practice of disarming felons like Mr. Swan. There is no doubt that the historical record shows there were individuals who are similarly situated to Mr. Swan, former felons at the time of the founding, and yet the government offers no analogous historical understanding of the Second Amendment at that time to meet its Step 2 burden under Bruin.
Let me ask you this. Is your argument foreclosed by law of the case?
No, Judge McHugh, I would not say it is. I believe Your Honor is referring to...
The footnote.
Yes, footnote 7. No, I would not say so, Your Honor. First off, law of the case cannot come from dicta, and I would say that that statement is dicta. The court said it was not going to be reaching that issue. Certainly, the footnote indicates no analysis or engagement with the issue in substance. It is not unusual, I would say, for a court to decide a case on a narrower basis than it might have decided it. But the fact that the court noted that in footnote 7, I don't think would rise to the level of being precedent. And what I would say as well is that I don't believe that's a position that the government has previously taken. This case has not been cited as precedent in any other firearms case. So, for example...
Well, if we were to read the footnote differently than you do and to say that it's not dicta, would you agree that law of the case would foreclose your argument?
If it's not dicta, Your Honor, I still don't know how to interpret the scope of that holding. If that does rise to the level of precedent, what the court said in that case was solely an outcome basis. We note that this would be foreclosed. There was no engagement with the analysis or argument, Mr. Swan.
What it said was that we've already decided this in Vincent, and you can't prevail.
Well, what the court decided in Vincent was a question about firearms.
Well, I'm not asking you whether that footnote is correct. I'm asking you if it's not dicta, does it foreclose your argument here?
Well, the way the parties presented the argument in Swan 1 did not draw the same distinction on firearms versus ammunition that Mr. Swan draws today. And so to the extent we are interpreting that footnote and its application of Vincent, I think it would be overreading it to apply it in that circumstance.
Is there authority out there that distinguishes between firearm and ammunition?
Certainly, Your Honor. I think, first off, the simplest and best evidence of it is the fact that Congress treated them separately by presenting them in this disjunctive, and of course, the executive routinely charges ammunition-only cases here. So they are two distinct things presented disjunctively in the statute. I think that when you get to the Bruin Step 2 inquiry, that is a contextual question based upon the historical record and based upon the fact of how Congress previously at the founding approached this regulatory issue, and to the extent that it did, as we have laid forth in our briefs, it did conceive of these things as two separate objects of regulation.
Are there any cases that analyze it that way and say, sure, we thought this for firearms, but no, it's different for ammunition?
I am not aware of any case that would have drawn a relevant legal distinction in the manner I think Your Honor is suggesting right now.
And that you're asking for, right?
Yes, Your Honor.
Under Bruin Step 1, it's got to be an arm in common use for self-defense. Your client cannot have a gun, so you're talking about ammunition only.
Mm-hmm.
I mean, that's no different than having a pebble to throw at someone. Doesn't have a firearm to make it a lethal weapon. What do you have to tell us that bullets alone, ammunition alone, is an arm for purposes of the Bruin Step 1 analysis?
A couple thoughts on that, Your Honor. First off, what I would say is that to the extent we are talking about the Bruin analysis and the word arm in there, I think I would caution against overreading that term in the Bruin Step 2 analysis. The Supreme Court
Step 1.
I'm sorry, Step 1 analysis. The Supreme Court has often said that its opinions are not to be read with the precision that one would say statutes. I think the relevant inquiry is whether or not ammunition would be protected under the Second Amendment.
Well, on the question of whether it's the second prong of the first step is whether it's an arm in common use for self-defense. And here you have a situation where we're talking about ammunition to be possessed by someone who cannot lawfully possess a firearm. So you're just looking at ammunition. I mean, you know, do we have anything to suggest that it's commonly used that for home defense, people throw bullets at an intruder?
I see what you're saying now about that. I don't.
Well, the ammunition's no good without a gun, right?
Well, Your Honor, if we are to take a step back for a moment, if we were to say that because Mr. Swan cannot have a gun, therefore he cannot have ammunition, it would either be an expansion of Vincent and McCain beyond what those cases
No,
said.
what I'm saying is because he can't have a gun, ammunition is not an arm. Ammunition alone is not an arm in common use for self-defense. That's what I'm saying.
Well, I don't think the character of ammunition would change based upon the individual possessing it, Your Honor, for the constitutional analysis. I think that ammunition is protected under the Second Amendment. As a broad statement of fact, ammunition is protected under the Second Amendment. It is a necessary concomitant to...
Well, certainly if you have a right to have a firearm, you can't prohibit the right to have ammunition because it renders your firearm ineffectual for self-defense. But if you cannot have a firearm, I'm not sure that the opposite is true.
Well, with respect, Your Honor, I think that this is a difficult question because most constitutional rights are not physical objects that interrelate with one another in this fashion. But it is often true that Congress permissibly limits or derogates certain constitutional rights, and it does so based upon whatever the standard of review might be. But to say that Congress has permissibly done X does not imply anything further about further derogation of rights. Many constitutional rights imply corresponding rights, the right to receive information, for example, as the right to speak, the right to not speak, the right to speak. The fact that Congress can limit one of those doesn't imply any derogation of any implied other right.
Unless, of course, one piece of it is completely useless without the other piece of it, and you don't challenge the prohibition on the gun.
Well, I don't think it would be completely useless, Your Honor. I mean, ammunition is...
What are you going to do with it? You've got ammunition, somebody's breaking into your house, you do not have and are not allowed to have a gun. how is it commonly used for self-defense?
Well, I don't think that what the court is saying in common use for self-defense implies that your constitutional right is restricted to the actual uses for self-defense. Hunting would be a great example. One can hunt, it's not a use for
Throw
self-defense.
the ammunition at a deer?
Well, Your Honor, there are many ways in which one can use ammunition apart from use for self-defense. One can,
That's not the question. Are there ways that you can use the ammunition without a gun, is the question.
well, Your Honor, what I would say is that the Bruin Step 2 analysis, the Bruin analysis,
I'm in Bruin 1.
I'm sorry, I keep getting that tripped up, is not solely dependent on a particular use. The question is whether the object is in use for self-defense, for hunting, target shooting, any one of these other objects. Ammunition can only be used in a firearm, that is true, but one can purchase ammunition for a friend, one can use it for other purposes, and one can sell it, one can engage in other things that would be constitutionally protected and would be subject to the Bruin analysis that is not the actual act of self-defense. But more broadly, so Harrison teaches that to the extent that the dispossession, a modern dispossession statute is based upon a legislative judgment about dangerousness, that has to be substantiated. That is what prevents the Second Amendment from falling to be subject to only rational basis review. And I think that the government here acknowledges this burden in its answering brief, but it does not attempt to meet it. It invokes the historical tradition of regulating dangerous parties and regulating that use, but does not engage with what that actually would require in this case, which is a reason to believe that that legislative judgment is accurate, more than rational basis review. One other thing I would note as well, at the Step 2 analysis more broadly, the government has not pointed to any relevant historical understanding or tradition of disarmament. There were, at the founding, as I mentioned, there were obviously felons like Mr. Swan who had reintegrated back into society, and the government does not establish that there were any dispossession statutes of firearms or ammunition relevant at that time. And I would direct the court in this respect to footnote 10 from the Duque Ramirez case from this past December. The historical record is a matter of party representation and party advocacy. The court is entitled to rule on the record which has been presented to it. In this case, the government has not pointed to any historical history or tradition of regulation that would support the restriction as applied to Mr. Swan. The court has no further questions. I would reserve the balance of my time for rebuttal.
Very well.
Well, before you, don't you have a second issue?
Yes, Your Honor, as well. In the sentencing here, the court gave a maximum level sentence for the imposition, a statutory maximum sentence for conduct which it recognized was minimally culpable. Possessing 17 bullets is, as you might expect, perhaps the least culpable way of violating this statute, and nonetheless gave a statutory maximum sentence. It did so because it ignored the potential for disparate sentences, as Mr. Swan raised at sentencing, and by focusing on punishing Mr. Swan for conduct other than the conduct of the offense, for what it perceived as Mr. Swan's history of domestic violence. Those are very serious allegations, and those are very serious allegations I'm not downplaying, but they are unrelated to the act of possessing ammunition in this particular case. And combine those two would make this case that sentence substantively unreasonable.
Thank you.
Thank you.
May it please the court, Stephen Krager on behalf of the United States. I'm going to start with the Second Amendment issue since that is where the court spent most of its time. I would submit there are two analytical paths that this court could take to affirm. I think the proper path to take, and it's a path that's inherent even in the attempt that Mr. Swan attempts to make to distinguish ammunition, that ammunition is ultimately necessary for the operation of a firearm. It's encompassed within the use of a firearm. And as a result, it should be viewed part and parcel with a firearm. Viewed in that way, Vincent v. Bondi covers this case, and as this court explained in Swan 1. So the first analytical path is simply to say ammunition is entitled to no greater protection than the firearm itself. Vincent controls, end of story. The second analytical path is the path that Mr. Swan has asked this court to take, which is to treat ammunition alone as constitutionally different than a firearm. This runs into a number of problems, not the least of which, as Judge McHugh's questions, I think, narrowed the issue, the burden is on the defendant to demonstrate that ammunition alone, without reference to a firearm, because that's the distinction he chose to make and stand on, is an arm protected by the Second Amendment. And as the Supreme Court explained in Heller, it defined the term arm as a weapon of offense. As this court explained in Rocky Mountain Gun Owners, it's the challenger's burden, in this instance Mr. Swan's burden, at Bruin Step 1, to show that it is an arm. Mr. Swan has failed in that burden. Specifically, I point the court to page 15 of Mr. Swan's corrected opening brief, where he admits, quote, ammunition is, on its own, hardly dangerous at all. One cannot use ammunition in an offensive manner without a firearm. I would submit that right there demonstrates Mr. Swan has failed in his burden at Bruin Step 1, and there is no reason that this court needs to go to Bruin Step 2.
So counsel, I'm sorry, what about footnote 7? You're not going with the law of the case?
Your Honor,
Or is that path number 1?
I think that is a sub-path for path number 1.
A sub-path.
So I think you could say Vincent controls, end of story. I think you could also say that footnote 7 of Swan 1, which incorporates Vincent v. Garland, also controls. So whether you say law of the case or prior precedent based on Vincent, I think both of those are the same analytical road.
Okay, thank you.
The only other thing that I want to touch on with regard to the second analytical road is Mr. Swan's counsel argued that ammunition alone could be used for things like purchasing for a friend or trading or economic purposes like that, which are not Second Amendment purposes. They're not being used for self-defense or hunting for things that you would use an arm for. They'd be goods and commodities in that instance. And so I would submit that doesn't carry the burden either. Unless the court has any further questions regarding the Second Amendment issue, I'll briefly touch on the substantive reasonableness of the sentence. Mr. Swan's major argument is that, has been that the district court didn't adequately address the need to avoid unwarranted sentencing disparities. This is untrue for, that's incorrect for a number of reasons. First, the district court explicitly said that it addressed that it considered all of the 3553A factors. And that's at page 348, and then again at page 351 of volume 5 of the Record on Appeal. The district court also properly calculated the guideline range. And as the Supreme Court explained in Gall, which was a variance case, when a district court properly calculates the guideline range, it necessarily gives weight and great weight. It necessarily gives great weight to the need to avoid unwarranted sentencing disparities. At the end of the day, the need to avoid unwarranted sentencing disparities is but one factor for the court to consider, and it's entitled to give it as much or as little weight as it needs, at least as reasonable. Here, the district court explained that Mr. Swan's history and characteristics, specifically his eye-catching brutality against women going back many years, was one of the big things that drove the sentence. Another thing being that he was told countless times that he can't possess firearms and ammunition, yet continued to do so. I think it's also notable that Mr. Swan received a 100-month sentence in federal court for being a felon in possession of a firearm just a few years before this incident took place. In fact, he was off supervised release for that incident for less than a year before he possessed ammunition in this case. As a result, the district court gave a sufficient explanation as to why it imposed the variant sentence that it did, and Mr. Swan has failed to show that that sentence is an abuse of discretion. Unless the court has any further questions.
Was the maximum sentence then 10 years or 15?
It was 10 years, Your Honor. This is before the Bipartisan Safer Streets Act. Unless the court has any further questions, I would ask that you affirm the judgment and sentence below. Thank you.
Thank you, Mr. Krieger.
Thank you, Your Honor. So, because ammunition is required to make this primary right of exercising firearms, make firearms effective in practice, the Second Amendment must reach and protect the use of ammunition. It does so both directly because it is necessary to make the right to bear arms effective, independent of being arms. It is required to make bear arms effective. And secondly, derivatively of that, the right to keep it, to make firearms effective and the right of self-defense. So to say that the Second Amendment reaches ammunition must mean that Mr. Swan's conduct here was constitutionally protected in some way. It would be an expansion of Vincent and McCain to expand those cases to this case here today. And I would say that there is nothing in those cases which took Heller's dicta on casting doubt on the prohibition of firearms. There would be no analysis or reason to expand those cases here today. And to the extent the court proceeds from first principles under the Second Amendment, the result would be, as we say in the answer brief. I would touch on the Gall question as well. Counsel pointed out that Gall states that to calculate the sentence, there is a giving weight to the need to avoid sentencing disparities. What this court has said in other cases is that a within guideline sentence that has been properly calculated is entitled to a presumption of substantive reasonableness. This is a major variance. Mr. Swan did not get a guideline sentence. Mr. Swan got something significantly in excess of his guideline sentence. And so to what extent the Gall implies a consideration of this factor in the calculation of the sentence, that cannot be enough to overcome the absent analysis here today. Unless the court has any further questions, I thank you for your time.
All right, thank you. Thank you, counsel. The case is submitted and counsel are excused. The next case for argument is United States versus Knox. It is docket 256011. Counsel, please proceed when you're ready.
Thank you, Your Honor, and may it please the court. My name is John Bolin of the firm of Bolin and Shaw, appearing on behalf of defendant and appellant, Mr. Antonio Knox. Now, in writing the affidavit that supported the search warrant in this case, Detective Wooten really only knew that Mr. Knox's car was either shot at or shot from in this shooting between two cars. He didn't know whether Mr. Knox was in the car. None of the evidence could tell him. He didn't know whether Mr. Knox, if he was in the car, was the driver or passenger. And he didn't know whether Mr. Knox was the shooter. So our contention is that Detective Wooten embellished the facts a bit to try to get this search warrant to be issued by the court in 5 ways. The first way was that he claimed multiple witnesses had ID'd the vehicle, the Chevy Avalanche, that turned out to be Mr. Knox's vehicle. But in reality, only one witness had said that they had seen a Chevy Avalanche that day.
Well, didn't the district court look at that and say that although one witness was speaking, there was another witness standing there and affirming through body language and not objecting to anything?
No, Your Honor. There were 3 witnesses involved. One officer spoke to one.
I'm not talking about the people who said shooting at the house. I'm focusing on whether this statement could be perceived as being accurate.
No, it could not, because there were 3 witnesses. One officer talked to one witness who said Chevy Avalanche. A different officer talked to 2 witnesses, one of whom was silent and the other one who told them about the shooting, but that witness did not mention the Chevy Avalanche.
What difference does it make? You've got to test for the district, the neutral magistrate, whether there's a fair probability that evidence might be found And if you have one witness who tells the officer this as opposed to witnesses, why does it matter?
Your Honor, that bolsters the affiant's position on the matter.
If we took it out, would it make any difference in whether there was enough to issue the warrant?
I believe that all 5 of these embellishments taken together are the reason why it went from not probable cause to search Mr. Knox's house to the magistrate judge issuing the warrant.
Do you contend that any of them singly suffice, or it's just a totality?
It's a totality, Your Honor, yes. Because there are several things here that were embellished, and it takes the entire picture from a picture where the police only know his car was involved and they don't know anything more about his involvement in this shooting, to you're saying now there are multiple witnesses IDing his vehicle, that he was speeding, which wasn't established, that there were gunshots from both vehicles when the...
Do you require on speeding that you have a radar gun to determine someone's speeding? I mean, we even let we don't even require a police officer to say a car was speeding.
Yeah, in some circumstances, it's easy to tell. In this case, the officer testified that it was speeding up. He heard engine revving, and that's what he knew. But he didn't say speeding up in the affidavit. He said speeding. He also said that gunshots were coming from the cars, plural, when he didn't know whether it was one or the other or both cars from which the shooting occurred. And also, he completely omitted the fact that casings found at the scene suggested that only the passenger and not the driver could have been the shooter, which suggests, if this is Mr. Knox's vehicle, the most likely scenario is that he is driving and not a passenger in his own vehicle, and a passenger shooting suggests he's not the shooter. Now, all this matters because we're not asking whether there's probable cause to believe that Mr. Knox committed a crime here. We're asking whether there's probable cause to believe that evidence of that crime is going to be found in his personal residence.
Well, do you need probable cause? I mean, you need probable cause, but the test is whether there's a fair probability that contraband evidence of a crime will be found in a particular place, right? That's the test.
Yes, Your Honor.
Okay.
And so here there wasn't a fair probability that the guns or ammunition used in the shooting would be found at his home. Now, there may have been a fair probability that some evidence of the crime could be found in his vehicle, such as maybe a cartridge casing, a hole in the vehicle from the other car shooting it, other kinds of evidence that's similar to that. But going all the way to his residence, there was no probable cause to believe that evidence of the shooting would be there.
Where would you expect the firearm to be? Under the car seat, that's a possibility. Probably not on the dashboard, but most likely the person's going to take the firearm inside the house, right? Just as a matter of common sense and odds.
Your Honor, it could be either way, but that would be the shooter. And we didn't have enough evidence to get to a fair probability that Mr. Knox was the shooter. All we have is that his car was involved. And the trial court, that's how it made its mistake. The government repeats that mistake here in the answer brief, page 27, and quoting the court saying, well, if he's driving the car that they're using for a drive-by, isn't there probable cause to believe a crime has been committed? And that's not the standard at issue here. We have to believe that evidence of this crime would be at Mr. Knox's house. And the Dalton case, for example, shows that where you can reasonably believe that that defendant was in possession of the weapon, then you could believe that he took it into his house, just as Judge Phillips just mentioned. But we don't have enough to believe Mr. Knox was actually in possession of the weapon that was fired that day. And in fact, the two firearms that law enforcement found in his house when they performed the search were not linked to the shooting. And so for all those reasons, I believe...
Is that relevant to our analysis here? I mean, it's not something the magistrate would know.
That's true. And so it's not something that the magistrate would have decided, and this court wouldn't take that into account in deciding whether the district court made a mistake in this case. But in hindsight, it was correct that Mr. Knox did not have evidence of the shooting in his house. And I believe that there was not probable cause to believe that there would be. On the Dalton case, because it was discussed in the briefs, there the probable cause was found because the defendant's car, the officers observed a gun in defendant's car. And there was testimony from the officers saying, well, if somebody has guns in their car, they're likely also to have firearms in their house. But importantly, in that case, probable cause disappeared once the officers knew that someone else had been driving the car that day. And so they didn't have the inference anymore that the defendant was in possession of the firearm in the car. And so, of course, the next chain in logic was also eviscerated, which is that someone who has a firearm in their car would also have it in their house. Now, what matters there is possession, because I think the government would say, well, we know a firearm was in Mr. Knox's car if his car was used in the shooting. But what mattered in Dalton was possession, because once they found out that the defendant was not the one possessing the car, and therefore also likely the gun.
But here we don't have any information that Mr. Knox was not in possession of the car at the time of the shooting.
You're right. We don't know one way or the other whether he was possessing the car.
Right,
That's
and in
correct, Your
Dalton,
Honor.
it wasn't they didn't know one way or the other. It was they knew he didn't have the car at that time.
Yes, that is correct, Your Honor. Unless there are no further questions on that topic, I'd touch briefly on our Second Amendment argument. I understand the court's decision in Vincent after Rahimi was to stick with its prior precedent and to follow the dictum of the United States Supreme Court on whether nonviolent felons, whether it is a violation of the Second Amendment to have the prohibition of owning firearms for non-violent felons. And on that point, I would just say I understand that this panel is bound by the prior decision of a different panel, but the court has never undertaken the historical analysis required by the Supreme Court through Heller and Bruin and Rahimi. And so I think it is incumbent on the court, now that the law has undergone a sea change from the original law on which this court decided that issue under the Bayer case, that it reassess the question under the new set of rules. You know, the Bayer case was decided back when this court was holding that the Second Amendment only protected the right of folks in a well-regulated militia to possess firearms. That all changed, obviously, a very long time ago. And the court has not really readdressed that issue. The court has only said, we're going with the Supreme Court's dictum that Heller did not alter the felon in possession statute, which has been repeated by the Supreme Court since then.
We have a case before the Supreme Court right now on this issue, at least with regard to marijuana users. Should we abate and wait for that?
That would be, I think that would be a prudent choice for the court. Yes, because I think that Mr. Knox qualifies. I know that the government will contend that he does not qualify based on other circuits that say drug crimes, for example, are a danger to the community and therefore under the historical analysis may have been regulated. I don't think that's true. There are a couple of possession with intent to distribute charges on Mr. Knox's record, and there is one burglary charge, but it specifically says in the pre-sentence investigation report that that was based on a stealth or fraud and not breaking and entering or anything else that could be conceived of as a violent. And I think the question to be answered is violence as opposed to the sort of loose danger to the community, for example, that drug distribution presents. If there are no further questions, I'll reserve my time. Thank
Very
you.
well.
Good morning, Your Honors, and may it please the Court. My name is Stephen Hoke, and I'll be arguing on behalf of the United States. This Court should affirm the judgment and the sentence of the District Court in this matter. As to the first issue regarding the suppression motion, the Court can affirm in three separate ways. First, by finding that the affidavit contained no misstatements or omissions. Second, even if there were misstatements or omissions, they were not intentional or the result of recklessness. And third, to the extent there were any misstatements or omissions, none were material to the legal effect of the warrant. As to the second issue, Mr. Knox's argument is foreclosed by binding precedent. Now, there were a line of questions regarding the statement from Detective Wooten regarding witnesses stating people in a white Chevy Avalanche were shooting in random directions. And I think what's important to distinguish is that that sentence can really be characterized as background or context for what's happening here. That was not the only basis for the identification of Mr. Knox's vehicle. The way that Mr. Knox's vehicle was identified was based on surveillance video from a nearby church and continuing to investigate this area and identifying that avalanche on multiple occasions based on some of its distinct features. So as to the statement itself, it would certainly have no legal effect on the legality of the warrant, even if this court were to find that it's an inaccurate statement. But at bottom, the district court below found, quote, that the facts attributed to the witnesses were accurately stated in the affidavit. That's volume 3 of the record at page 41. Now, certainly, as in any instance, as with any warrant, with the benefit of hindsight, can every warrant be more precise? Absolutely. Could the sentence have been reworded, broken down, better articulated? Yes, but that does not make it inaccurate. I want to also discuss the location of the cartridge casings, and there was quite a bit of discussion about that within Mr. Knox's brief. I think it's important here to review the record and note or acknowledge the fact that when these vehicles stop at the stop sign for the second time, or not for the second time, when they stop at the stop sign when they're seen for the first time, there's a volley of shots. And Detective Wooten was specifically asked about that volley of shots and what he took from that volley of shots. And he stated, quote, based off the video and not seeing any muzzle flashes on the passenger side, my belief was that the gunshots came from the driver's side. That's from volume 1 of the record at pages 474 to 475. So that's his belief. There was no, if he was putting in the affidavit that the shots came from the passenger side, that would have been inaccurate. He didn't specify what side they're coming out of because he can't tell. Some of the evidence, sure, points to maybe they're coming out of the passenger side at one point. Other evidence points to the fact that they're coming out of the driver's side. So there's no reason to delineate at that point any specifics regarding where these casings are being located. And Your Honors, unless there are any other questions about the first issue, I think I've addressed most of Your Honor's questions as to Mr. Knox's counsel regarding the first issue. I'll move on to the second issue, but that is just that Mr. Knox's argument is foreclosed by binding precedent in this matter. And with that, I just ask that the court affirm the judgment and sentence of the district court.
Thank you, counsel.
Thank you.
In response, I would say that Detective Wooten didn't mention anything about the casings one way or the other, and there was certainly evidence pointing toward the passenger side. If there are no further questions, then we would ask that the court reverse and remand.
All right, thank you. Thank you both for your helpful arguments. The case is submitted. Counselor excused.
Thank you, Your Honor.
Looks like we're ready. The next case for argument is United States versus Cangro, docket 25-2079. Ms. Davis.
Good morning, Your Honors, and may it please the court. Today, this case concerns the most protected space under the Fourth Amendment, the home. And to search one's home, the government needs probable cause, which requires specific, reliable facts that have a fair probability linking evidence of a crime to that home. That did not happen here. This is for two primary reasons. First, the government did not establish the required nexus between criminality and the Euclid address that was searched in this case. Second, the good faith exception cannot save this warrant affidavit. To the first point about the required nexus. Here, the government does list a myriad of facts purportedly alleging criminality, but that is not enough. There must be criminality that is linked to the home that is searched. Here, that did not happen. To start with the confidential informant's statements, which the government primarily relies on, the confidential informant made statements to Special Agent AC that Mr. Cangro could get drugs and guns for sale if the confidential informant wanted them. However, the confidential informant never links this to the Euclid address.
You admit there's enough from the confidential informant as to criminality?
There could be enough to assert some type of crime. However, this could also just be
A fairly specific crime.
yes, there could be evidence that there might be a crime of getting drugs and guns. However, this could be bluster of someone that wants to look cool. But
But you don't challenge that portion of the issue with respect to the affidavit supporting the warrant.
no, Your Honor, here
It's just the nexus.
correct, Your
between
Honor.
the Euclid property and that crime.
Correct. There is no nexus here between any alleged crime, which the confidential informant may have alleged enough for some type of crime to happen someplace, somewhere, but not at the Euclid address that was eventually searched. The confidential informant never links any type of evidence or even an insinuation that there is going to be criminality, evidence of criminality at the Euclid address. In fact, when this investigation started into Mr. Cangro in February 2022, the Euclid address was not even part of the investigation because only a few days prior to the execution of the warrant did Mr. Cangro purportedly start moving into the Euclid address.
We do have case law that suggests, I think Judge Phillips mentioned it on a prior case, that people who have firearms and also people who have drugs tend to keep them in their home.
Yes, there are several cases where that is enough when the confidential informant provides sufficient facts and there is corroboration showing that some type of criminality happened at the home. An officer's inference that drugs and guns are often kept at the home may be enough. However, that's not the case here. There is not enough. In all of those other cases, there was more that would lead to a reasonable suspicion that there would be criminality, evidence of criminality at the home, including that the confidential informant bought drugs from the defendant in those cases, saw drugs and guns at the residence, actually alleged to have been at the residence. Here, none of that exists. The confidential informant never alleges that he or she even saw drugs or the drugs that Mr. Cangro was purportedly going to sell, that the confidential informant even went into the Euclid address. So here, that would not apply because the confidential informant and the additional surveillance that SA agent AC did just is not enough. It does not show enough for a reasonable suspicion of criminality occurring at the Euclid address.
Counsel, do you have any cases that say what you just said, that you, well, a case that would say you can't draw an inference that drugs, maybe records of drug dealing or whatever, some evidence, we can infer that without having any direct observation? I mean, you're making a direct observation test, I think. And I'm wondering if there are any cases that say you have to have a direct observation, there's no inference.
I would not say there's cases that explicitly say a direct observation is needed, but there are cases where when there is not a direct observation or that direct observation is stale, it is not enough. For instance, US v. Cordova and US v. Roach both show that when there's some observation of officers or a confidential informant that there was even a drug deal or more than is in this case happening months prior, that is not enough to establish a nexus between the criminality and the home. Here, the only allegations are that Cangro could get drugs and guns at some point in some time. All of the cases that do find that there is enough of a nexus to support that inference that drugs and guns are kept at the home have more. So it's more of a compilation of cases showing that when that inference is supported, there is more evidence to back it up, or there is more of a reasonable suspicion to back it up.
Thank you.
So really you're basing it on it could have been bluster.
It could have been bluster, but even if it wasn't bluster, even if you want to assume that there was some type of criminality happening, criminality at some place at some point in time is not enough for the search of a home. There needs to be more. There needs to be that nexus to that criminality and the home.
And the drugs and the guns don't supply that by itself.
There are no drugs in this case up to this point. The confidential informant doesn't see any drugs, and the assertion that Cangro had a gun on his waistband happened months prior. And there are multiple cases, including US v. Roach, US v. Nolan, that state that in drugs and gun trafficking cases specifically, that evidence is unlikely to stay stationary, and that it's unlikely to be in one place for more than like weeks or a few months at a time.
Right. On appeal, Mr. Cangro is not contesting that he in fact resided at Euclid. Is that right?
No, the Euclid address was Mr. Cangro. There's a contention that Mr. Cangro, there's enough evidence to place him at that evidence, at least a reasonable suspicion. There was surveillance that showed moving boxes, Mr. Cangro going in and out of the house, so that there's not enough to support criminality at that home. In fact, the confidential informant even stated that Mr. Cangro was splitting time between different locations. So this even lowers the reasonable suspicion that criminality is going to be found at a home that he's purportedly moving into just a few days prior.
Assuming we agree with you that the warrant was based on insufficient nexus, why doesn't this fall under the good faith exception? We've put a pretty high standard on preventing a good faith exception. And that's based on Supreme Court authority. It's, you know, so why doesn't this fall easily within the good faith exception?
Correct, Your Honor. The good faith standard is quite a high standard to meet. Officers.
High standard for a defendant.
Exactly.
To
rebut.
defeat.
Exactly. However, this is for two primary reasons. First, that because the lack of nexus was so deficient on the face of the warrant affidavit, that there's just not enough for a reasonable officer to think that that something could be there. For instance, in Suggs 2, Chief Judge Phillips, your dissenting opinion even stated that we presume that officers know the law, including that there needs to be a nexus between the criminality and the home, and that when that's devoid on the face of the affidavit, then our inquiry ends there. There's just not enough, and the good faith exception does not apply. However, if your honors disagreed that they're just on the face of this affidavit, there is no nexus, which defendant contends that on the face it is not enough. There are material misrepresentations and omissions that were recklessly included in this warrant affidavit.
I don't, is that a new argument?
No, Your Honor, this is included in our briefing. So the reckless omissions here include that a reference to a probation officer search of 7 months old, that where Mr. Cangro was living with a then girlfriend, and that found certain contraband in the home, but this was 7 months prior, and Special Agent AC also lists out the types of contraband that was found at the home, the different investigation, including a picture that he links to Mr. Cangro of a purported gun. However, in the U.S. probation officer memo that Agent AC reviews to include this in his warrant affidavit, it's also stated that that gun is purportedly an airsoft gun that belonged to Mr. Cangro's girlfriend. Son. And so this is just one example of Special Agent AC cherry-picking information out of the underlying facts and documents in this case to present Mr. Cangro in the worst possible light. And
Is the universe of what you're talking about in your cut and pasted version of the affidavit?
sorry, could you?
The additions, the deletions, or no?
I'm not sure I'm understanding your Honor's question. I'm sorry. If in the motion to suppress, the affidavit does include all of these different omission strikes, the falsehoods, and that is included in the motion to suppress. And we do bring up in our briefing the various omissions and recklessly false information. I'm happy to.
What I'm talking about is there's an application for a warrant, and it is the application, but then there are things that are added into this, which I think are the points that you're making. For example, just opening it and not choosing any one particular. Paragraph 23, there's an addition. However, the lighting is so bad up here. In 2005, Cangro denounced his membership in SAC. That's not as part of the original.
No, that is
That's
an exhibit in the defense counsel's motion to suppress that they included to show had certain statements that were shown to be recklessly false or omissions that were excluded that should have been included were there. It would have shown that this there just was recklessly false omissions and statements that should have been.
And that's my question is, what's in this document with the additions and the deletions, is that the universe of what you're relying on for reckless or intentional?
Yes, Your Honor. So for instance, another example of where Agent AC cherry-picked information or just included recklessly false information was this connection to Mr. Cangro and the SAC, where it was shown in a document that Special Agent AC cited to a case that Mr. Cangro was involved in. In that same documentation that Special Agent AC reviewed showed that Mr. Cangro was actually a witness in that case and testified against his former gang. This is clearly material because even Special Agent AC at the hearing stated that had he known this information, that he wouldn't have even sought the warrant. So this is the very definition of materiality. If he had known or just looked a little further on the document that he reviewed, then he would have seen that this connection he was trying to make between the SAC and Mr. Cangro was just not accurate, and even would have led Special Agent AC to rethink this warrant affidavit, and he even said that we would not have been here today just when discussing the hearing because he would not have done things the same way. And if there are no further questions, I would like to reserve the remainder of my time for rebuttal.
Very well.
Thank you, Your Honors.
May it please the court. My name is Paul Mishlevietz. I represent the United States in this case. If it pleases the court, I want to correct a factual statement that my colleague just made when she told you during her argument that Cangro said he could get guns and drugs if the CHS wanted him to. That is not what Special Agent AC put in the affidavit. When you look at, I'm looking at Record on Appeal, Volume 2, page 58, paragraph 41, what the CHS reported to Brian AC was that Cangro had firearms and fentanyl for sale and to contact Cangro if the CHS wanted them. Obviously, if fentanyl is coming to Albuquerque from Arizona, which is the phenomenon that Special Agent AC was investigating, which led him to Cangro among other people, someone saying, I could get this if you wanted it, is not the same as, I have this, call me if you need it. And so I just wanted the court to be clear on what was actually in the affidavit there. This court should affirm the decision of Judge Garcia not to suppress any of the evidence in this case, primarily because the affidavit contains ample probable cause. And to answer your question, Presiding Judge Phillips, even Ms. Johnson, who was trial counsel for Cangro, even her version of the affidavit that includes all the things she might have liked Brian AC to have submitted to Judge Molson and withdraws everything she might have liked Special Agent AC not to have submitted to Judge Molson, even that affidavit has probable cause, which is one of the ways that you know that none of the statements that Special Agent AC made about Cangro or about his history or about the investigation of Cangro are material to the probable cause determination that Judge Molson made. Additionally, one of the legal things that my colleague said is that there must be a direct nexus between criminality and the residence to be searched. And as Judge Ide pointed out, she's really, to make is one verb, is the verb that Judge Ide used. But really, I would say that she's asking this court to make a rule that does not currently exist, that there has to be a direct observation of criminality at the house. We know that is not what we have, and one of the reasons we know that's not what we have is that the original warrant to look for drug and gun behavior by Mr. Cangro was for a different address, was for the Ross address. And when Special Agent AC prepared to serve that warrant on the April 13th, I think it was a Wednesday morning takedown, they saw in their surveillance, their pre-execution surveillance, that he had moved out. And so rather than search a place where he didn't live anymore, even though they may arguably have been authorized to do so, they ceased work and then started to find the place to which he had moved, which is where Brian AC sends the CHS out and says, go find where Cangro is now. CHS gives new and updated information about where he had moved to, and this is really contained most closely in paragraph 36, which is on page 57 of the second volume of the Record of Appeal, that he moved some of his property out to Edgewood, which, as you know, you could take judicial notice, it's about 30 minutes east of Albuquerque. But he's also staying in a house on a cul-de-sac behind the New Futures School on Cutler. Brian AC drives there, sees Cangro's car at this Euclid address, comes back another time with Special Agent Viramontes, sees the car again, sees another car associated with someone that he believes may have a relationship with Cangro at that time, and then seeks this warrant for the new and updated address. Of course no one has seen drug activity directly at that new address. The connection is between Cangro and the criminality, and then the new information is between Cangro and this new residence. And Special Agent AC was very upfront with that to Judge Molson when he sought this warrant that is now being challenged. The United States takes the position there's nothing improper about that. There's nothing reckless about that. There's nothing misleading about that. And if you look at Volume 3, which is the transcript of the, I think of it as a Franks hearing. I showed up ready for a Franks hearing. If you look at that transcript, one of the things Special Agent AC noted was that Judge Molson is not shy about telling him when she thinks his affidavit is insufficient, and he takes steps to correct that and present her with an improved affidavit. So that questioning was in the context of his good faith in the service of the warrant that he received from Judge Molson, but I present it now for the additional reason of explaining why the indirect connection between criminality and the residence, meaning the connection between Cangro and criminality and then Cangro and this new residence, which is endorsed by this court in its analysis in the United States against Mora, is certainly sufficient. We do not need a new rule that there has to be direct evidence linking criminality to the new address, and therefore the defendant loses on that requirement for the new rule.
One thing that I found a little troubling here was the court held a hearing that appears to be much like a Frank's hearing, and then said, well, I'm not going to consider any of the evidence that you came forward with at this hearing. That seems rather odd to me. I mean, shouldn't the court, once it holds the hearing and allows the defendant to come in and put on evidence, shouldn't that evidence then be part of the analysis?
This court has the power to make such a rule. I am not aware of such a rule already existing. As you saw with your review of the transcript in Volume 3, Judge Garcia did not do this because it's what I asked him to do.
But it does appear, I mean, it is a quasi-Frank's hearing.
Yes, I would say yes. And we know that if Judge Garcia had held a Frank's hearing as a matter of grace rather than of right, to borrow from Herrera, I would lose if I complained about that, and I'm aware about that. I went to that hearing prepared to help Special Agent AC defend himself against this attack against his integrity, against his honesty by Ms. Johnson, who was trial counsel for Mr. Cangro. And then I was as surprised as anyone to read the order that was published afterwards. I couldn't find any case from the 10th Circuit that says the technique that Judge Garcia used is not allowed. So I don't think it's reversible. But also importantly, what Mr. Cangro has not briefed here is how it would move the needle if you considered the exhibits that were introduced at that hearing, but that were not attached to the motion in which Mr. Cangro sought the hearing. You don't have any analysis before you of, oh, well, if the transcript of the probation search came in, that would have sufficiently undermined probable cause so that Judge Molson wouldn't have granted the warrant for the new Euclid address. Or Brian AC, assuming this panel finds that probable cause is deficient, despite all my arguments and despite the contents of the affidavit itself. Let's say this panel says the affidavit was sufficient such that we need to rely on good faith, as the district court did. There's no analysis that says if these exhibits came in, here's how you would know that Brian AC didn't serve that warrant in good faith and therefore government loses. That has just not been briefed to the court.
Is it more than exhibits? Was there testimony that would fall under that as well?
Yes, and it's my position that there was not really any persuasive power behind the testimony, which may or may not be why Judge Garcia ended up taking the procedural route that he took.
Well, you say it as though it was by design. Was it just confusion?
So I'm mostly trying to refer to Volume 3, which is the transcript. There was a point at which I had Brian AC on the stand, and he was talking about his good faith and how he has great respect for Judge Molson and does whatever she tells him, expeditiously. And Judge Garcia indicated that he found the dialogue boring, or that he wasn't interested in that, and that he wanted to talk about the facial warrant challenge. And I told him, I said, the CMECF notice we got was that the court was setting a hearing on the defendant's motion for a hearing. And the hearing the defendant moved for was a Franks hearing. So I showed up ready for a Franks hearing. Brian AC showed up ready to defend his honor against these attacks from Ms. Johnson.
And the defendant showed up for a Franks hearing.
Yes, she was ready. Ms. Johnson was ready. She had her own witness who testified after Brian AC. But in this dialogue with Judge Garcia, he basically said, listen, I'm just not very interested in this. I'll let you make your record if you want. And what I said to him was, it's not a matter of, and I think I'm recalling my words correctly, but please look at the transcript, Volume 3, to be sure. It's not that I want to make a record. There's an open attack against the integrity and the honesty of this agent. And if you say Frank's challenge denied, defendant loses on Frank's, okay, we can move on to oral argument on whether there's PC on the face of the affidavit. But while the attack on Brian Acey remains live, I'm not going to stop doing my job as a government attorney to defend him. And he's certainly not going to quit giving true and faithful testimony under oath to help the court understand his good faith in executing Judge Molson's warrant. And then after Special Agent Acey testified, the defense investigator testified, whose job, someone might disagree, I consider her to have been called to criticize Brian Acey and say how she would do better.
That's all very interesting, but
Yes.
At the end of the day, for me, the question is, how do you hold a hearing which is, looks like a Frank's hearing, quacks like a Frank's hearing, everybody treats it as a Frank hearing, and then you say, I'm going to make my decision, but I'm not going to look at any of the evidence that we took during this Frank's hearing. I find that rather odd.
I have never seen it before, Your Honor, and I did not invite it, as you see from the record.
Okay, so let's, before we run out of time.
Yes.
What if we say we don't want to deal with any of this and we just say, let's look at the good faith exception? According to your friend, we can't apply the good faith exception here. Do you think that is correct, and if not, why?
I think it is deeply misguided. As you can see from from Erlinda Johnson's proposed affidavit, even with all the additions the defense would want, and even with all the deletions the defense would want, the affidavit is not so lacking in probable cause that Brian Acey wouldn't trust that Judge Molson granted it correctly. Meaning, what we heard today was essentially a facial bad faith challenge that the affidavit was so obviously lacking in nexus that Brian Acey would not trust that Judge Molson granted it correctly. And that is just not following this court's law as set out in United States against Cotto, United States against Roach, United States against Campbell, which are all cases about even a minimal nexus is enough to support the good faith execution of a warrant. Here, our position is the nexus was entirely sufficient to contain probable cause, but even if we skip ahead to good faith analysis, as Judge Garcia did, there is nothing deficient on the nexus to drop it below the cases in which this court had said the execution was in good faith. Additionally, if you do look at the transcript, you will see that none of the statements Special Agent Acey made in that affidavit were, the United States takes the position they weren't wrong, but even if they were incorrect or incomplete, then they were not material to probable cause, or they were not, and additionally, they were not recklessly made. There is one thing I do want to focus a little bit on in the very little remaining time I have, and it's this idea that Brian Acey is supposed to believe James Cangro when Cangro says he's no longer involved with the Soldiers of Aryan Culture, despite sending new selfies after getting out of prison with the swastika tattoo still on his stomach, despite the Soldiers of Aryan Culture tattoo still across his stomach, even though, as Special Agent Acey testified, people who go to federal prison and are on federal supervision afterwards have access to services to remove or to cover up tattoos like that. Special Agent Acey specifically said in the affidavit that one of the components of his training and experience is that folks will lie to conceal their gang ties, and I'm directing your attention to paragraph 44, which is on page 58 of Volume 2, Record on Appeal. Much of the complaining from the defense about the Soldiers of Aryan Culture, which is essentially, by the way, background. There is very few paragraphs in which Special Agent Acey describes on pages 51 and 52 the Soldiers of Aryan Culture, but the reason he's asking for the affidavit is saying that he can provide fentanyl, saying that he has guns and fentanyl to sell, call him if you need them, and then the investigation that leads to his new location. The Soldiers of Aryan Culture stuff is fundamentally immaterial. I see that I'm out of time.
Let me, With regard to the pictures included of the cat with the gun, should he have revealed that that was not a gun, that it was what was it, an air gun?
So one of the, if I may answer despite my lack of time,
Yes,
Your Honor.
please.
The search where the guns were sought, but the probation office told Laura Christie in advance they were coming, and then they found real Glock magazines and a real Glock magazine loader, and then got some pictures of guns with a cat. I don't know whether that particular gun was an airsoft gun or a real pistol. It doesn't look like a Glock to me, I can tell you that. Brian Acey wasn't the guy who did that search. Brian Acey found out about that search that had previously been done by the probation officer. And so he wasn't there for the dialogue, he wasn't there for the description of the gun, he wasn't there to say, are you telling me this gun in the photo is an airsoft gun owned by your son? And then he wasn't there to see Laura Christie's demeanor when she answered that question. He's picking up this investigation later. There's no real way for him to know whether that picture is of a real gun or not. So we take the position, the United States takes a position that he didn't do anything reckless by telling the judge what he knew, and he didn't know that that wasn't a real pistol. And also, I don't have any indication that he was present for or have ever had the transcript of the dialogue from that probation search that Ms. Johnson tried to enter into the record at the, let's call it a Frank's hearing. You saw, if you read Volume 3, my objection to that exhibit, which is that it wasn't authenticated by anyone who was a participant in the conversation. It was just something that they hired a non-participant to write out based on the audio recording. Subject to any other questions, that's what I have, and the United States respectfully requests this panel affirm the decision of the district court. Thank you.
Thank you. And let's give counsel another 2.5 minutes so the time has been even. You don't have to use it.
Thank you, Your Honor. Thank you, Your Honors. First, I would like to address the point about the Franks hearing. While it is unclear what exactly process happened here, on page 111 of the hearing transcript, Judge Garcia does say he will allow the hearing, presumably meaning the Franks hearing. And the fact is that Judge Garcia did allow evidence, and it was pertinent to the issue at hand. In U.S. v. Herrera, the court stated that we should err on the side of more process to see that justice is done. And the issues at hand are showing in the information that was excluded by Judge Garcia, that was attached and presented at the Franks, not Franks hearing, show the reckless cherry picking of evidence and information that Agent Acey included in his affidavit to the magistrate as the drafting and executing officer, including citing to the probation officer memo where it in fact does say on the same page that the gun with the cat was an airsoft gun. So he had that information. It was on one single page that he cited to. And even if we say that even Agent Acey says in the hearing transcript at pages 69 through 70 that things would have been different had this information been included, like the dropout information that Cangro did in fact drop out of the SAC. And an agent with 22 years of experience knows the law, knows that a nexus is required. And unlike my co-counsel or my opposing counsel here said, that it's not just a nexus between criminality and the defendant and the home. It's evidence of criminality and the home, as is shown in U.S. v. Nolan, where even it states that even repeated instances of drug activity outside the home is not enough for a nexus. Thank you.
Thank you, counsel, for your arguments. The case is submitted. Counsel are excused, and we're going to take about a 10-minute recess, and we'll pick up when we get back, it appears, with United States versus Kelley. Thank you.
Court is in recess for 10 minutes.
It's part of the record of appeal.
Okay, that's what I figured, I just.
If you check your brief, I'm sure there are citations to it.
Yes, no, that's okay. For Jackson, they have below guidelines. For some judges. Not all.
I assume you know what Judge McHugh's first question might be.
Absolutely. I'm okay with that. I mean, it will help clarify. I would think at least.
Yeah.
Are you supposed to? It's like that wasn't a facial, kind of like, it's interesting how the conversation turned into, I wasn't expecting it.
What?
I don't want to know when really like, I was like,
Oh, yeah.
Like so far
The Robitussin or the
yeah.
Appalachian, right? I think it was somebody on the Coast College who mentioned that I guess it was like Aaron Rodgers who got caught with the
Do I sit here and wait for them to call me up there once they go to it, or? I never knew what
I
was
think
the
if
right.
you, when you see the judges, go to the bench if you want to go up there. You can.
Okay, thanks. Ready, I guess. Ready as I can.
The Honorable Judges of the United States Court of Appeals for the 10th Circuit.
Please be seated. All right. Not only did I forget my lamp, I forgot my glasses, but I do know this is United States versus Kelley.
Oh, do you want me to get your lamp?
Please announce it.
No, do you want me to get your lamp?
No, that's all right. It's 6194. Please proceed when you're ready.
Good morning, Your Honors. Laura Deskin on behalf of Mr. LaQuevin Kelley. I am here to argue that 922G3 is facially unconstitutional. I understand that facial challenges can be difficult, but I want to explain further why I believe that 922G3 is facially constitutional. First, the government is incorrect that all it must do is point to one hypothetical application of the statute that would not violate the Second Amendment. In Doe from this circuit, this court rejected the argument that all the government must do is imagine a hypothetical situation in which a statute could be constitutionally applied. And Rahimi did not abrogate Doe in that sense. Rahimi criticized the Fifth Circuit's concern that domestic violence protective orders, when it was analyzing 922G8, that they could issue unfairly or as a tactical device in divorce proceedings. They kept referring back to that concern, which really sounded in due process and not the Second Amendment issue at hand. And then we must look at what Rahimi actually did in that case. They did just as this court did in Doe. They weren't looking at hypothetical applications. They were looking at the terms of the statute itself. So I think
Rahimi says the government need only demonstrate that Section 922G8 is constitutional in some of its applications.
correct. It did say that, but then what did it do? It didn't, it could have held, well, 922G8 is constitutional. Let's just look at Rahimi himself. This is a very dangerous individual who I think in that case, he had demonstrated through previous conduct that he was a dangerous individual. The defense in that case couldn't even argue against that.
Applied challenge.
No.
I mean, there's a significant difference between the two, and you've made a facial challenge here. I guess I'm not persuaded that the government has to do anything other than show us that there is an application of the statute that is not unconstitutional in order for it to survive a facial challenge.
Well, I think that you would have to go, you could go back to Salerno itself, where this idea came from. There as well, they were looking at exactly what are the terms of that statute, that being the Bail Reform Act, which had many provisions, many things that the government had to prove in order to find a person dangerous such that they could hold them in detention. And so they looked at all those prongs to say, well, we think that in that case, due process is not violated, nor is the Eighth Amendment. And in 922G8, they were looking at this statute that says that requires a finding, a judicial finding, that a person represents a credible threat to the physical safety of an intimate partner or child. That's what they were looking at.
Rahimi, when it says a facial challenge is the most difficult challenge to mount successfully because it requires a defendant to establish that no set of circumstances exist under which the act would be valid. Is that dictum or?
No, I accept that. The question is, how does that work? You have to look at how the statute itself works. So this isn't a departure from that guidance at all. What the government here is doing is they say, well, it could apply to somebody who is intoxicated at the time, but the statute itself by its terms does not require that whatsoever. Every application that it...
So it has to be an application where that's actually an element?
That the statute requires.
So the statute couldn't be broader than intoxicated persons. that it would have to specifically require a finding of intoxication?
If the historical, so going into the Bruin analysis, if the historical
Well,
principle,
I'm just trying to understand what you think a facial challenge requires.
I think a facial challenge requires looking at what the terms of the statute itself do require for conviction and determining whether or not that itself is violative of the principles in Bruin.
So that sounds like you're turning it on its head, which is that what you're saying is if there's any circumstances in which you wouldn't fall under it, or it wouldn't be constitutional, you throw out the whole thing.
Well, again, you have to go back and look at what exactly does each statute actually require. This is far afield from 922G8, where they look at, well, what are we doing here? What is a court doing when they are convicting somebody of 922G8? Well, you're looking and saying, well, was there a finding previously that this person represented a credible threat to the physical safety of an intimate partner? That's what you're looking at. Those are the terms. And that they found was facially constitutional. They did not have to go out and say, well, what was the problem with what the Fifth Circuit was doing is that they were going out and saying, well, but I mean, somebody could be found to be a credible threat, but that could have been an unfair process, or, we know that people bring these protective order proceedings out of vengeance in a divorce proceeding, and that is where that criticism came from in that case, because they were going and hypothesizing outside of what the statute required. Whereas here, we have a much different statute. All you have to be is an unlawful user of a controlled substance. Any controlled substance on all 5 of the controlled substance schedules will work. And the statute tells us no more. So to be convicted under this, it does not require the government to prove that they're intoxicated. It does not require them to prove anything beyond the fact that they meet the definition of an unlawful user, which is a judicially created definition, and that they are an unlawful user of a controlled substance that is on the schedules. So and that's why I think it is different. So
Well, counsel, maybe I can stop you there. Are you arguing that for a facial challenge, you just look at the face of the statute, you don't think of any applications?
I am looking at what you look at what the statute would require the government to prove in this case. It does not require it to prove intoxication at all. So in Rahimi, the court didn't hypothesize some subset of activity that was encompassed by 922G8 to find it constitutional facially. It wasn't difficult to find that statute facially constitutional. Congress itself designed that subset in the statute itself very explicitly. Here, we don't have anything beyond these very simple terms of this statute that comports with history and tradition. That's the argument.
Thank you.
So once you get past that, if you are looking further into, okay, so does this idea of disarming an unlawful user of a controlled substance, does that comport with history and tradition? I would say
if we are looking at a person who is currently under the influence, who's intoxicated either by drugs or alcohol, that it would dovetail pretty cleanly with disarming dangerous people historically, wouldn't it?
yes, I would agree with that.
So your argument, in order for you to prevail here, we have to agree with you on your view of how a facial challenge works.
I think so. I think that is what it requires, honestly. The idea of it is because some people who are unlawful users of controlled substances and possess a firearm, some of them might possess one at the time of intoxication. That whole idea of taking away a firearm from somebody, and it's not permanently, but the idea of dispossessing them of that use temporarily does match up with the prior drunkard laws, essentially. But they were really just laws saying, well, on New Year's Eve, on these May Day, you are not allowed to shoot off a gun. If you do, that's a criminal act. There are some differences here. We have this can get you up to 10 years in prison, up to 15 years in prison, and is the how of it can be differentiated, actually, but I will give that we do have that history of disarming intoxicated users. And we're talking here as to unlawful users, not addicts. I have not engaged in that, which I think is a separate analysis.
How is your argument different than the argument being made in U.S. versus Hamani, which is before the Supreme Court right now, which is a as-applied challenge to a marijuana user? I mean, to me, it seems like you're conflating a facial challenge with an as-applied challenge.
Well, here we're not as different, and that's why we didn't ask to abate for Hamani up front, because I wanted to make this argument as to how facial challenges, I think, should be analyzed based on the way it has been analyzed in previous facial cases.
But I guess you are not bringing an as-applied.
No, this is purely a facial challenge. And that's what differentiates it from Hamani. That is as applied. Now, if you've listened to the oral argument that took place in Hamani, they veered very far away from marijuana and discussed substances up and down the schedule, which is why I would not be opposed to abating this case for Hamani to see where they go in that case. It might give us a little bit better roadmap for how one analyzes the history and tradition in this particular context. And I will reserve the remaining part of my time. Thank you.
May it please the court, Stephen Craig on behalf of the United States. Given the argument that was just made that this is largely a question about how a facial challenge is handled, and if a facial challenge operates the way that the government has suggested, then that it essentially ends the inquiry. I plan on focusing on that. As Judge McHugh's questions have focused in on, Rahimi adopted the Salerno approach with one small caveat. Because in the Second Amendment context, the burden shifts to the government once you get past Bruin Step 1, the government has to demonstrate that a statute is constitutional in at least some applications, as opposed to the challenger having to demonstrate that there's no application that is constitutional. So the question here is, what are applications? And this court in Harrison answered that question rather easily. Specifically, this court said, even among individuals who use marijuana, Section 922G3 applies both to those who are intoxicated while possessing a firearm and those who are not. It talked about two different applications, those who are intoxicated, those who are not intoxicated. This case involves, as a facial challenge, this court can focus on those who are intoxicated. Mr. Kelley's approach to facial challenges is the exact approach the panel opinion in the Fifth Circuit and Rahimi took. Yes, they talked about due process and there were concerns with that. But the problem, the error that the Supreme Court identified with their application of the facial challenges is that the Fifth Circuit focused on the situations where the statute was most likely to be unconstitutional, and saying, if it's unconstitutional in those situations, the statute on its face is unconstitutional. That is not what Salerno provided, and that's not what Rahimi provided. Doe doesn't lead to a different result for a couple of reasons. First, Doe questioned whether Salerno remained a viable test. But even to the extent Salerno had remained a viable test, Doe pointed out that there is no one test that applies to all facial challenges. This court need not say that Rahimi abrogated Doe. It could simply say that Rahimi adopted Salerno for purposes of Second Amendment challenges. And in doing so, again, the burden is on the government to show there's at least some applications that are constitutional. I'm happy to get into any other issues the court may have, but again, in light of the the argument of my opponent, I'm not sure if there's anything else to talk about. If there are no further questions, I'd ask that you affirm the judgment and sentence below. Thank you.
So I don't think that what the Supreme Court and Rahimi did was adopt Salerno as the test for facial constitutionality of Second Amendment challenges. Bruin is the test for constitutionality of Second Amendment challenge. History and tradition is. And so you can look at, does this statute, by its terms, comport with history and tradition? By its terms, it does not. What the government is required to prove in every single case in which 922G3 is prosecuted does not comport with history and tradition at all.
Isn't the argument that you're making that by its terms means that every application has to be constitutional under Bruin?
Well, I think that every
Isn't that what you just said?
Well, you don't have to look at, like, what you're asking me to do is to say that, well, if the person is intoxicated, then isn't it okay? No, because the government doesn't have to even allege that or require that. And the 922G3 doesn't call for that whatsoever by its very terms. And so, yes, if you look at just the terms of the statute, in every application of the statute, it is unconstitutional because it doesn't require the government to prove any of these other things that it says makes it unconstitutional. And that, constitutional. That was the case in Rahimi, that was the case in Heller, that was the case in Bruin, that was the case in Doe. You are looking at what is mandated by the statute itself. And so that is my argument for why 922G3 should be held to be facially unconstitutional. I think it doesn't work as a whole, and doesn't in terms of history and tradition. And my time's up.
All right. Thank you, counsel,
you.
for your arguments. The case is submitted and counselor excused.
Thank you.
Looks like council is assembled. Our next case for argument is United States versus Diaz. It is docket 256028. Council, please proceed when you're ready.
Thank you, Your Honors. May it please the court, my name is Lynn Hartfield and I represent the appellant Michael Diaz. Now, the first two issues that I've raised require the court to take a hard look at the strength of the evidence in this case, albeit under slightly different standards. With regard to the 404B issue, the government doesn't really contest that it was error to admit that conviction. It was not relevant to either intent or knowledge. And I would draw the court's attention to the Third Circuit's opinion in Caldwell that thoroughly sets out why a felon in possession conviction is not relevant in a case like this. Now, the district court also didn't conduct a Rule 403 balancing as required by Lizgado v. Lobos, which compounded the error. However, the government's real argument focuses on the harmless error analysis. And that standard requires the court to look at whether the error substantially influenced the outcome of the case, which in turn requires an assessment of the strength of the evidence and the probative value of erroneously admitted evidence. So here, looking at the strength of the evidence, the alleged victim, Austin, testified that he came home to pick up a piece of clothing and he found Mr. Dias in his home. Austin and Mr. Dias then had a verbal altercation, which was captured on video. And then Mr. Dias left the home and Mr. Austin chased him out of the home. And at that point, the video stops. If we only had Mr. Austin's testimony, there wouldn't be a lot to say here. But we don't. What we have is a video of the altercation before Mr. Dias allegedly pulled out a gun. We have a 911 call, and we have a body cam video from the responding officer. Now, there are 6 different things that undermine Mr. Austin's testimony, and I just want to draw the court's attention to those things. The first is the demeanor of the two parties on the cell phone video. What we can see is that Mr. Austin is enraged. Understandable since he found someone in his home, but nonetheless, he was extremely enraged. He threatened to kill Mr. Dias several times. He's extremely angry. Mr. Dias, on the other hand, is fairly calm, and he's just trying to de-escalate the situation. So again, when you just look at the demeanor of the two parties and you had to guess which person pulled the gun, it certainly would seem.
Well, the cell phone video was played for the jury, right?
Yes.
Why isn't this a credibility determination for the jury?
Again,
You're talking about demeanor. I mean, that is right in the purview of what a jury does.
Well, it is true that the jury makes credibility determinations, but this court still has to look at whether the evidence was sufficient under a beyond a reasonable doubt standard. And the Goldsberry decision is the case that I think the court should look at the most closely, because in that case, we also had different witnesses testifying. Some testified one thing.
We had actually one. Anyway, I don't think this case is close at all to Goldsberry. There was not a video of what happened in the bedroom in Goldsberry.
And nor was there a video of what happened regarding the gun. We have a video of what happened before the gun was pulled. But we certainly don't have a video of what happened at the time the gun was pulled. And similar to Goldsberry, we didn't have the defendant testify, but we had other people talking about what the defendant said in Goldsberry. And here we have the defendant captured on video saying, I didn't break into your house. Let me get out of here. Let me pick up my belongings. I will leave.
But couldn't a jury look at that just the opposite of what you are, which is to say a firearm can be used for defense as well as offense, and certainly the homeowner was very aggressive and continued to pursue, and there were threats, and as you said, understandably, very upset about that. And as I look at that video, right before it breaks off, it looks like the defendant is trying to reach inside of the yellow toolkit, trying to reach inside, and then it breaks off. Why wouldn't it be a reasonable inference that indeed he got the firearm out of the toolkit and the homeowner ran away? Well,
certainly I think that the evidence, Mr. Dias did not have the burden of proof here. And what I am saying is that the evidence was about 50-50. We have, the Mr. Austin's testimony, and then we have all of the things that cast doubt on it. And it's not just the demeanor.
The fact that he says, I wasn't the one shooting, doesn't seem that odd to me, given, we're talking about a black man who's facing with the police. We have plenty of cases where you want to make very clear, I'm not the shooter here.
And that's certainly,
The jury could, the problem that I have with your argument is that all of this seems to be asking us to put ourselves in the role of the jury here. And, you know, I don't, you know, that's not what we do.
Well, that's certainly, you know, the law is that the jury's verdict is entitled to deference. But at the same time, this court doesn't just abdicate its responsibility to look at the beyond a reasonable doubt standard. And when we look at the evidence, not just bits and pieces, as Goldsberry makes clear, we don't just look at like, well, okay, he could have said, I wasn't the shooter because I'm a black man in Oklahoma City, and you know, that's reason enough for me to have said that. We look at all of the different things. So we have the demeanor, that's one thing. We have the 911 call. We have the evidence that Mr. Dias walked into an unlocked building rather than broke in. And again, if somebody is going to burglarize a building, they're more likely to have a gun than if they just happen to walk in. We also have the location of the casing.
You're going to rob me and come into my home to rob me? And do we have any authority for the proposition that if the door happens to be unlocked, I'm going to get rid of the gun that I happen to have with me?
Well, there's no evidence that he took anything. And so again, we don't know whether he went in there just to take shelter. It was a cold day. If you look at Mr. Dias on the video, and there's evidence, of course, in the PSR, which was not given to the jury, that Mr. Dias was homeless. But we know he's got all these belongings on him, which doesn't look like somebody burglarizing a home. It looks like somebody potentially just ducking in to get warm.
Is all of this in the context of harmlessness?
Yes. It's in both. I mean, I think both the sufficiency standard and the harmlessness standard require the court to look at the strength of the
And
evidence.
so on sufficiency, with my first point, how I would look at that video, and my observation that an angry man with a firearm probably isn't going to wait for 20 seconds or whatever it was before he displays it and starts shooting. Those sorts of things on sufficiency go to the government, right?
You know, again, I think we have to look at what the inferences that flow from the evidence. And nobody is saying that.
Of a sufficient, I think what Judge Phillips is saying is when we are reviewing sufficiency of the evidence after the jury has convicted, we have to take all inferences in favor of the government.
If they flow from the evidence, and again,
Well,
there's.
it has to be reasonable inference.
Yes, it has to be a reasonable inference. And again, there's nothing that says that Mr. Austin had to have the gun on him when he walked into his home. And in fact, that wouldn't make much sense. He had just gone to work. He left his car running. He ran in the house. So it's not likely he would have had a gun with him. On the other hand, people do keep guns in their cars. And the video cuts off before any gun is pulled. The other things that should.
Just argue that the inference supports the verdict.
I think, you know, again, individually, you could go either way with each piece of evidence. You could say, well, you know, with respect to the demeanor, Mr. Austin was angry because he found someone in his home.
And for those sorts of things, on a sufficiency, we can't go either way. We can only go one way, and that's in favor of the verdict, right?
I think when you look at all the evidence together, it's the whole of it. It's like not taking each little individual piece and saying, well, let's take this inference in favor of the government. It's saying, look at everything all together. And are we giving every inference to the government and then on top of it, not looking at the beyond a reasonable doubt standard? That's what Goldsberry teaches. But, you know, either with the 404B harmless error analysis and with the sufficiency analysis, you have to look at the strength of the evidence. It's just that the sufficiency standard is a greater burden, and I do understand that. However, because they're related, I think we have to discuss the evidence in both contexts. But that is not even, that's only some of the issues that are problematic in this case. The other is the location.
I can see how you would lose on sufficiency and win on harmlessness. So why aren't you just arguing harmlessness?
Because I think that it's the same evidence we're looking at. I mean, I certainly
The
think.
standard's different,
The standard is different, but it's the same evidence.
but the standard is better for you under harmlessness
Absolutely.
than sufficiency, so.
Absolutely. So, I mean, I think it's a no-brainer that this was not a harmless error. But I think we have to look at the evidence, and that's why I'm going through it. I think under either standard, he should win. There are different remedies. Obviously, with the 404B, I don't have as high a burden, and I think it's pretty clear that the error wasn't harmless. If that's what the court is going to rule on, then he gets a new trial. If the court doesn't agree with me on the sufficiency, then the conviction is not vacated. He only gets a new trial. But it's the same evidence that the court is reviewing. And so I'm merely pointing to the issues that made this really a 50-50 case, or for harmless error, maybe it only needs to be a 60-40 or 75-25 case. But in any event, the evidence wasn't strong. And adding in that Mr. Dias had been convicted of exactly the same thing.
Well, the evidence was the victim testified, he pulled a gun and shot at me.
That wasn't the only evidence, though. We had the video, we had the location of the casing, we had the timing of when the weapon was pulled. So there were a lot of different things that were given to the jury. And then there were a lot of things that weren't given to the jury, such as interviewing the neighbors or doing any forensic testing. None of that was given to the jury. And all of those things together made this not a particularly strong case. And adding in that prior conviction really tipped the scales unfairly in favor of the government. So I'd ask
And on that point, we do look and see how much was it emphasized. And the answer here is it was one answer to one question and never mentioned again, right?
Well, that was the same as the Comanche case, and the court reversed in the Comanche case, and it's similar. 404B evidence is particularly strong because when you've got the jury going, there's some weird things about this case, but that guy, he's been convicted of the very same thing. That's enough to tip the scales, and that's what makes this not harmless error.
Comanche was using a knife, and on this occasion, he used a knife, so he must use the knife on this occasion. That's a lot different.
We had felon in possession again, and in fact, the jury wasn't told the circumstances of that felon in possession conviction, which actually involved, his girlfriend's kid taking a gun and shooting it, not him. But the jury wasn't told that. They were just told he was convicted of having a gun when he shouldn't have. And that's the same thing that he's being charged with here. If the court doesn't have any further questions, I'd reserve my time. I don't know if the court wants to discuss the sentencing issue. If the court has.
In your court, if you want to speak about it, speak, and otherwise you can reserve your time.
Your Honor, I think I will just reserve my time and stand on the briefing on the sentencing issue.
All right, no further questions.
Thank you.
Sounds good.
Morning, Your Honor. May it please the court, Tanner Larkin for the United States. Since my friend on the other side mostly focused on the evidentiary issue and harmlessness, I'll focus there.
Well, can we first clarify, do you concede it was error to let in the prior conviction here?
So, Your Honor, we don't think the court needs to reach that question.
Well, I'm not asking you don't tell me what to do on my job. I'm asking you, do you concede?
If the court is inclined to reach that question, we would concede that it was error in this case because this is a very unusual case, Your Honor, which involves actual possession, but also the defendant actually firing the gun, where the defendant did not put knowledge at issue.
Right, okay.
We're talking harmlessness. We can just move on to that.
Yes, Your Honor. So this error was harmless for two reasons. First, just like in Kupfer, this evidence played only a very minor role at trial. As in Kupfer, this came up in a single exchange with a single witness.
Yeah, there is that saying, dynamite comes in small packages.
That's true, Your Honor, but I think if you look at this case, this evidence was not dynamite. It was a blip on the radar for the jury.
Then why ask?
Well, the government did not know what the defense case was going to be, and so it didn't know if knowledge was going to be at issue, and that's why it brought this in. But it brought it in only in a single exchange with a single witness. It did not attempt to capitalize on this in closing argument, and the district court gave a limiting instruction, which said that this could be considered for knowledge and no other purpose. And since the only issue in this case was possession, that meant that the jury did not consider it for the only thing that was really at issue. And in this case, proof of possession was proof of knowledge, which makes this such an unusual case. As for the strength of the evidence, the this is not a 50-50 case, Your Honor. It's not even a 75-25 case. This is not a he said, literally, because Austin testified under cross-examination, and the jury found him to be credible. Meanwhile, Diaz not only did not testify, but put forward zero evidence, as the government pointed out in its rebuttal statement to the jury. In addition, if you look at Austin's actions, they confirm his account. If you had just committed a crime, the last thing you're going to do is immediately call 911 and try to get the police there as quickly as possible, and then immediately show them the video you filmed of what happened right before the crime.
Unless the neighbor really did see him fire the gun. And there's some evidence that's offered that the neighbor was implicating the homeowner.
Well, Your Honor, I'd point out in that video, we don't know what the neighbor actually said. So we know the neighbor said something, and Austin said, "It wasn't me." But I think that's a perfectly reasonable reaction when you're the only person at the scene of a crime. The other person has fled, and for all you know, that person is never going to be found. It's perfectly reasonable to seek to dispel any doubt. So that's Austin's demeanor. He takes the video, he shows it to Officer Howard within 10 seconds of his arrival. But what does Diaz do? He flees. Ordinarily, flight is evidence of consciousness of guilt.
A burglary.
Yes, but I think if you actually look at the manner in which he fled, he didn't just try to flee. He risked his life to evade capture. When a police officer pulled a firearm on him, he flipped the middle finger and kept running. And when a police dog tackled him, he attempted to gouge out the eyes of the dog. I would suggest that this is not the action of someone who thinks that he is facing his 5th state burglary rap. It's the action of someone who realizes that he is in more serious trouble than that.
I mean, that's a lot of speculation.
Well, Your Honor, I think it is important to realize that the defense put forward a theory in this case. It put forward zero evidence to call into question the eyewitness testimony of Austin, which the jury heard him testify and found to be credible, and was substantiated by the other evidence, including, of course, Diaz's flight, but Officer Howard's testimony that Austin was consistent in everything that he told him. And I think if you look at the strength of the evidence here, and you look at the way in which this conviction barely came up, and the fact that the district court told the jury, you may not consider this for anything other than knowledge, in a case where proof of possession was all but conclusive proof of knowledge, it's hard to see how this could substantially influence the verdict in this case.
How far away was he when he was captured?
About half a mile, Your Honor.
Right, and no firearm was ever found.
That's right. So he made it at least half an hour before he was caught. Made it about half an hour. He went through various people's backyards. He went through this drainage ditch, which had some vegetation. And we know that he ditched the power box, because that was found. We know that he ditched the backpack, which was found, which contained illicit materials, wallets, women's clothing, items that suggested that he had recently been engaged in burglary. Those are large objects.
Were they in the same place?
I don't know if those two items were in the same place, Your Honor. But we had testimony from the police officer that this is precisely the kind of area we could hide a gun and have it not be found. So it really is not at all surprising that it was not found in this case. Unless the court has any further questions.
Well, talk a little bit about harmlessness. It's your burden. What do you have to show?
So what we have to show in a non-constitutional error case such as this is that the evidence that was admitted did not substantially influence the outcome at trial or leave a grave doubt about that. And again, what this court has looked to is how was this evidence used in the context of the entire record, context of the entire case. Again, we have something that came up very briefly for the jury. The government did not attempt to capitalize on it in its closing argument. And even the defense counsel correctly told the jury that we're not here about what happened in 2019. The district court told the jury, don't consider this evidence for anything other than knowledge, and it specifically warned against propensity reasoning. Meanwhile, we have a strong case here. We have the testimony of the eyewitness. We have other evidence that corroborates his account, and there was zero evidence on the other side of the ledger.
What's other evidence that corroborates? Mr. Austin's account?
Well, I think the fact that he called 911 within about 30 or 40 seconds, if you listen to that video, he is literally breathless. His first instinct is to try to get the police on the scene, which I would suggest is consciousness of innocence.
What was the question that elicited the response, if you have it in front of you?
So, Your Honor, the prosecutor asked the case agent, detective, have you looked at the defendant's criminal history? Yes. Are you aware of a 2019 conviction in Oklahoma State Court for being a felon in possession? Yes. So he was convicted of that? Yes. And then the defense counsel in its cross-examination asked the witness, so this was a plea, not a jury trial, correct? And the witness said correct. So this is very different from the Comanche case where you had questions put to two separate witnesses where they went into a fair amount of detail about the violent acts. As this court said in McLaughlin in the 403 context, if you put in a prior conviction with all the details, the court is going to be a lot more concerned that is going to influence the jury. But if you only put in the fact of the conviction, that is much less likely to have a substantial influence on the jury.
And I agree with you on Comanche. I think that's different. But if we affirm here, is that the new normal? Go ahead and ask your one question about, has the person been convicted of a felon in possession and never mentioned again, and hope that the reverberating bell continues through jury deliberations?
That's not the new normal, Your Honor. I think in this case, this 404B evidence had very little probative value for the government. The government had a very strong case. It didn't need this.
I've seen a lot stronger cases than this one. You can say it's a really strong case, but nobody other than the homeowner says he had a gun in his hand, for one thing.
Well, I think one way of looking at it, Your Honor, is when the government went up to give its closing argument, it didn't mention this. It mentioned all of the other evidence in this case, because that's what it felt was what was important for the jury to be thinking about. So I think, had we known that the defendant was not going to put intent, knowledge at issue, this is not something that would have come in the first place. So the government would not, risk an issue to be, discussed on appeal because it really was not necessary
So what
to
it
build
comes
this
down to
case.
is this: you're saying, please don't have a grave doubt.
Your Honor, this is not a grave doubt case. I think this is very similar to Kupfer, where you have something that comes in very briefly, like in Kupfer, where it's asked, where it is not in the closing argument, just like in Kupfer, and where there's a limiting instruction, which this court has emphasized in Becker in many cases is relevant for the 404B harmless error analysis. And again, this is a very unusual case. In the mine run of cases, we're talking about constructive possession cases where knowledge of the gun, and specifically of the gun's presence, is going to be the key issue. This is an actual possession case, but not just an actual possession case where the government's theory is that the defendant fired the gun. It's hard to see how he could have not known that the item in his hand was a gun, and that's why this is, yes.
Once you get that far, you got it won, I agree. If he fired a gun, you win. But that's not where we are. Got to concede you a lot to have that.
Well, I think it's important that the jury was not presented with any contrary evidence, any evidence to undermine the credibility of Austin. If you look at the defense attempts to find inconsistencies that simply aren't there in his testimony. He, for example, never actually says on the video that the shooting occurred in the grassy area rather than the parking lot. He never says that the door was broken when he first arrived as opposed to during the struggle. I think it's important to remember that many of the arguments you're hearing from defense counsel are the exact arguments that were put to the jury, and the jury did not find them to be very persuasive, simply because even though this is maybe not the strongest case that this court has ever seen, it is a case where there is ample evidence on one side of the ledger and absolutely nothing on the other.
Any further questions? All right, thank you, counsel.
We ask the court to affirm. Thank you.
Well, I would agree with counsel that this was a very unusual case. We do have one eyewitness, but the eyewitness was the alternate suspect. And we have to look at his testimony in that light. And when we look at his testimony in that light, there are so many things that undermine his testimony that it makes the case one in which it could have gone either way. The only way we get to Mr. Dias being the assailant here is to engage in speculation. And certainly, under a sufficiency standard, the jury is entitled to do some amount of speculation, but under a harmless error standard, we're looking at the strength of the evidence, and it just wasn't there in this case. So I'd ask that the court reverse Mr. Dias's conviction. I think the court could go so far as to vacate the conviction because sufficiency just isn't there. But if the court stops short of that, then I'd ask that the court reverse his conviction and order a new trial. Thank you, Your Honor.
Thank you, counsel, for your arguments today. The case submitted and counsel are excused. The next case for argument is United States versus Jackson. It is docket 25-6052. Counsel, please proceed when you're ready.
May it please the court. My name is Bonnie Bloomert. I am a federal defender, and I am here on behalf of Darius Jackson. My argument today will consist entirely of discussion of the first issue that was originally briefed regarding firearms and relevant conduct. Mr. Jackson has conceded the second issue regarding domestic violence, a domestic assault conviction as a crime of violence. What remains is that this case is about guns that Mr. Jackson never possessed, guns that other individuals possessed and sold. Those guns are not relevant conduct under the guidelines, and the trial court erred in finding them to be so. It did not make the required findings. It made no distinction between co-conspirators, and then incorrectly concluded that the acts of others were within the scope of jointly undertaken activity.
Why is that wrong? Jointly undertaken activity, why is this not a good definition? Jointly undertaken activity, even if you're not the one selling the firearm, if you benefit from being in a group that's together and selling firearms and watching out for each other, that sounds like plenty to me. Why not?
So there has to be some sort of agreement as to what the person believes they're doing, and certainly believing you are benefiting in some way, believing you're helping your friends
Well, they're
conduct sales.
all in the car together and probably not by accident.
They are in the car together, Judge. They ride there. But what's missing from the record is whether those individuals specifically got in the car to go to this sale. That's not clear. There's indications that the person that they know who invites them to this transaction is with the undercover officers and with this confidential informant. And this person texts at least one individual in the car to come to the site, to the location. It is not clear that the other people involved are intending any specific action at all when they're on their way there. We don't know if they even really know what's going on before they get there. So when they arrive, the first person gets out to start conducting a gun sale. The other individuals don't get out of the car. They stay in the car. They stay in and they let this other person do this transaction. They're not involved in it. They're not engaged with it. They don't.
They hand them $400 and say, here's $4 for your strap.
So there's no specific evidence about what exactly that statement means. Certainly we can extrapolate that the slang term strap is in reference to a firearm. But because Mr. Jackson is not out of the car during that sale, and then the sale that he actually undertakes on this separate day, on the second day, he does that sale himself. So what it may seem actually is that that statement is money about a previous agreement that they have. There's a debt there that Mr. Hawley owes Mr. Jackson money. So Mr. Jackson certainly receives the money from that sale, but receiving money from any sort of transaction doesn't mean you're co-signing the transaction, that you're involved in it, invested in it. This person owes you money. However they get that money isn't up to you, and that's not.
Isn't this a lot like the illustration number 8 to commentary 1B1.3A, where they talk about people walking across the border together for mutual assistance and protection? There's nothing in that illustration that talks about that they had to come to an agreement. You know, it's just that by grouping up, they all benefit from it.
Is this example Your Honor is talking about where they go collect backpacks from an individual?
They receive individual shipments from the supplier at the same time and coordinate their importation efforts by walking across the border together for mutual assistance and protection. Under this scenario, each defendant is accountable for the aggregate quantity of marijuana transported by the 4 defendants.
So in that scenario, there is a specific, an affirmative understanding that that is why they're together. They go.
Where do you get this affirmative understanding, and why isn't such affirmative understanding equally implied by the facts here?
So in that example, of course, we don't have the benefit of a full record. The example just says, these are the facts, this is what's happening. They have agreed to do this together. In the example, in our case.
Well, it doesn't say they agreed to do it together. It said they walk across the border, giving each other mutual assistance and protection.
For them to be at the border, to have received this package at some point in advance from whoever this other individual is, lets us understand very clearly that they receive these backpacks, they go to this location, and then walk across together. In our scenario, we have individuals that are at a certain location, but we don't know that they know when they get there that they're doing something together. This is all extrapolations that the court has to make.
All in the car together, they travel together in the car to the place where the criminal activity takes place. I mean, I see it as very similar to the illustration.
They are similar, but our case lacks the specific facts that tell us that that is what's happening. The government has the burden to put on evidence to show what exactly is going on, to know what the facts are before the court so it can make its analysis.
What's the alternative view, that they're in the car for some other reason? What's the other reason?
If they're riding around with their friends and they're doing something and then one individual says, hey, I got a text, I want to go over here and sell my gun. Or we don't even know if he tells the other individuals in the car what he's going to do. That's not in the record. It's not clear. And so
What's the overlap in the people on the 2 different occasions, the next day and the day before?
So Mr. Jackson, the defendant in question, on day 1, he has one individual with him, Mr. Beach. On the second day, Mr. Beach is also present, and then there's 4 other individuals. Those individuals are not present on the other day. We only know one of those other individuals by name, Mr. Hawley, that gets out of the car that sells a firearm.
And we have 6 firearms here that are used for the guideline application. All you need is 3 for 2 levels. How do the 6 come into play, and why do they not have 3?
So certainly, Mr. Jackson has his one from August 12th that he sold at the gas station. The other gun that Mr. Hawley sells can be attributed to him.
Do you concede that?
Because he takes the money for it. I think that's a reasonable inference, essentially. But that leaves us with 2 guns. The other firearms that Mr. Beach possesses, and then the ones that are in the car, are the additional ones that put us over that 3-gun threshold. The firearms that are in the car are never used in this sale. The individuals keep them with them. They're sitting in the back seat. They never make any attempts to get out, to brandish them, to threaten anybody with them. And they are essentially just sitting back there with them. And the only reason we even know that those are there is because somebody asks Mr. Hawley, do other people have guns? And he just says yes. He doesn't say anything about what they're for. For all we know, they just carry them on their person all the time. They make no effort to get out of the car and sell those firearms.
Let me ask you this. The district court concluded that there was an implicit agreement between Mr. Jackson and other members of the group to facilitate each other's sale through, at a minimum, logistical and protective support. And based on Jackson's pattern of coordinated travel and presence during other transactions, he jointly undertook with his co-travelers the transportation, possession, and sale of multiple firearms. Are those findings of fact that you have to contend are clearly erroneous?
They are improper extrapolations based on the quantity of the evidence present. So the Ellis case and...
That might be how you challenge them as clearly erroneous, but I first want to know what the standard of review is here. If these are findings of fact, do we review it under the clearly erroneous standard?
So we review relevant conduct de novo. To constitute clear error, an evidentiary finding that the evidentiary sufficiency of a court's finding in here as to the scope of jointly undertaken activity, we review for clear error. To constitute clear error here, we must be convinced, this court must be convinced, that the sentencing court's finding is simply not plausible or permissible in light of the entire record on appeal. So if that's the standard that we're analyzing the court's findings, the ones that Your Honor just read, those are impermissible in light of the entire record, because what the court did was focus on what would otherwise be some innocuous pieces of information, that Mr. Jackson is present with individuals, that he traveled with individuals, and that everyone there is armed. But we have to look at the entire record, and the court ignored numerous specific facts. The court ignores that the sales are conducted individually. The court ignores that the sales are done one by one, that each person gets out, does his own negotiation, that he decides how much the gun costs. He decides whether he makes the transaction, and then he gets back in the car when it's done so somebody else can get out and do theirs. There's also a slew of information that's missing. We don't understand the exact agreement, the knowledge of the individuals that they have when they arrive there, specifically on day 2. That is missing. The government could have put on text messages, witnesses, any other additional evidence to show what those individuals thought they were doing when they got there, what they think is going on, and what they're participating in. And that's the exact question that the court is supposed to determine. What is the jointly undertaken criminal activity? What do they each agree to by themselves? We can't just understand that the conspiracy or the agreement overall is to make gun sales, because we have to say what each person specifically agreed to. That Ellis requires that, Melton requires that, Figueroa Labrada requires that, and this court doesn't do it. The court just says...
The cases that you all just rattled off, they're either conspiracy cases or aiding and abetting cases. Does that matter? That's not what this case is.
It doesn't matter. The 1B1.3 guideline basically says whether or not it's charged as a conspiracy. It is irrelevant. Whether people have specific conspiratorial agreements can be factors a court considers in making this determination, but there's no need to have a specific conspiracy, because jointly undertaken activity for the purpose of sentencing attribution as relevant conduct can be different than just conspiratorial liability. Because co-conspirators, you might be under that theory, you're in for a penny, in for a pound.
It can be broader.
It is broader. So
That favors the government.
The court has to say, though, what each person agreed to. And in Melton, the individual there, he agrees to participate in this money counterfeiting operation. But his specific agreement is he gets the building and he helps with providing some manpower to sort of guard and work on it. After he's arrested, there's an additional quantity of money that is printed later. certainly that would be part of the conspiratorial agreement, that he understands he's agreeing with others to print fake money, and it would be foreseeable that they would print large quantities of it based on the equipment that they had. But the court found that because of his specific agreement, it did not cover that money, that even though that money would have covered you in a conspiracy, it didn't cover for this purpose.
Well,
Because
and that's why in a conspiracy case, it's, the court has, the sentencing court has to be more careful because you've got the overall conspiracy and then you have individual participants. Can you point me to a case that has the same kind of parameters where it's neither a conspiracy nor an aiding and abetting charge?
I don't recall finding any in particular where individuals were charged separately as they were here. It's not clear to me why the individuals in this case were charged separately. There's a footnote that the other two were charged in the Western District and were prosecuted for their conduct in connection with this. But, and I see, Your Honors, I'm essentially out of time. I would like to reserve the remainder for rebuttal.
Try that. May it please the court, I am Beau Bottomley on behalf of the United States. The district court properly found four firearms possessed and sold by others were attributable to Mr. Jackson as relevant conduct. First, I would like to address the defendant's argument that the district court did not make particularized findings as to the scope of the jointly undertaken criminal activity. Second, I would like to address whether his findings regarding the scope were clearly erroneous. First, the district court understood the need to make particularized findings as to the scope of the jointly undertaken criminal activity. He read on the record 1B 1.3. Then he went through it. He then stated that he must make a particularized finding as to the scope of the jointly undertaken criminal activity, considering any explicit or implicit agreement fairly inferred from their conduct. First, the jointly undertaken criminal activity is a criminal plan or scheme undertaken by the defendant in concert with others. Here, the district court stated the criminal scheme and plan was to, on multiple occasions, transport, possess, and sell multiple firearms to the undercover agents. The district court stated the record reflects that on at least 2 occasions, the defendant agreed with others to provide logistical support and protective support to carry out that plan. That's the scope. Additionally, the district court, in a statement of reasons, did adopt the PSR. What I want to jump into next is just the facts. And again, as this court stated, this court reviews the evidentiary sufficiency of the district court's findings as to the scope of the jointly undertaken criminal activity, only for clear error.
Just to straighten me out, and I'm sure you're right and I'm wrong, but you said 4 firearms. I'm looking at paragraph 12 of the PSR, or at least a PSR, that says the offense involves 6 firearms.
Yes, Your Honor. I was talking about the 4 firearms that were possessed by the others. So I would attribute there was 1 firearm on day 1 that was paid for and he received the cash. That to me is very clearly his. And then on the second day, he hands another. So I'm specifically talking about the 4 others. So on day.
Okay, I understand. Is it 2 or 6? That's the choice? In other words, there's no way to get to 3, 4, or 5?
I mean, I think you could find, this court could find on day 1, they would attribute all the weapons to the defendant, but not day 2. But I think the stronger argument, because they're pretty similar, is that all 6 are attributable to the defendant, Mr. Jackson. The district court did not clearly err when it concluded regarding the scope that the defendant and others had at least an implicit agreement to provide each other logistical, and by saying logistical, transporting the firearms on day one, and then sharing location information as to where they were going to meet up with the undercover agents, and then protective support, providing protection with their person and, of course, with their firearms. I think it's important to look at the bigger picture of what's going on here. The other undercover agents have communicated to this group of gentlemen that they want to buy firearms, they want to transport them to Kansas City, and then they want to sell them at a higher price. So that's kind of the big picture of what Mr. Jackson, Mr. Beach knew, and then there was certainly others involved. Now, what did Mr. Jackson want to do? What did Mr. Beach want to do? Mr. Hawley and Benford, they wanted to be the supplier of those firearms. So on day one, we see Mr. Jackson actually, after he's done the sale, he actually goes into the car of the undercovers and looks at where they store or hide firearms, such as they would do when they were transporting them to Kansas City. So this is not just a one-time thing. He is seeing that our goal as Jackson and Beach is to keep supplying so they can keep distributing. So he goes in there, he sees that. On day two,
I'm sorry, I'm not following. You think that Jackson going and looking in the undercover officer's car to see how they store the firearms is evidence of his implicit agreement with the other defendants?
I would say yes, but I think more importantly, it's his understanding that we are going to supply you firearms not only today, but going forward. And so it seems to me that it is a kind of a group understanding. We as a group are going to be providing you firearms. And then practically, how are they going to do this? How are Jackson, Beach, and the others going to do it? They're going to do it through logistical and protective support. And so just looking at August 12th, so that's day one, the undercovers arranged to buy firearms from a Mr. Benford and his associates. They pick up Mr. Benford. He then makes a phone call to another person, and then they arrive with 2 firearms that they intend to sell. So there is logistics going on there. There's transportation. Now, this is an inherently dangerous situation. Anybody coming into this situation, it could be inferred that they are going to tell their associates why we are going to where we are going and why you need to bring your firearms. This is not a situation, it would be unreasonable to say that these 6 persons coming in the vehicle didn't know why they were there. And specifically, we know that 2 firearms were seen by the undercover agents. One was an AK-47, and then another was a pistol. Now, why is that important? Now, it may be difficult to kind of hide an AK-47, but it's easy to hide a pistol, right? In fact, we know that they were all supposedly possessing firearms, but only 2 of them were seen. I think that's important to go as to the intent of the people in the car. Why were they there? They were there to be kind of a show of force. The evidence indicates that this was their first meeting, right? So Mr. Beach, Mr. Hawley, Mr. Benford, they don't know who these people are. Are they to be trusted? Are they dangerous? I mean, clearly it is a dangerous situation. So why are all of these other men there? They're there for security, and that's what they're doing.
Wasn't it possible that Jackson gets into the car and he's with friends and he doesn't really know what they're up to? I mean, should he then be liable for everything that these people do?
Is it possible? Yes, it's possible. But again, the standard is the district court's findings plausible? Can it be inferred based on the evidence? And again, what we would state is this is an inherently dangerous situation that they're going to. Usually people in this situation aren't just going to bring another witness to see them commit a crime. They're going to bring along people that they know are part of what is going on. And again, this goes to what can the judge reasonably infer? What is plausible?
Well, on day one, Mr. Jackson actually participates. I think we can assume we know what they were referring to a firearm when they gave him the $400. On day 2, is there any active participation by Mr. Jackson other than he's there as support and protection?
Yes, Your Honor, as I read the PSR, Mr. Jackson, let's see, Mr. Beach sells, he sells an Anderson Manufacturing multi-caliber pistol, and then Mr. Jackson sold the Springfield pistol. So he actually sold that one. And then what we also see afterwards, again, as we're looking at the bigger picture, the undercover agents, they say, hey, we are buying so that we can sell in Kansas City. Mr. Jackson, Mr. Beach, hey, we're going to be your suppliers. What we see at the end of that second day is Mr. Jackson communicating to the undercovers that he wants to sell them machine gun conversion devices. So again, we have a plan. We're going to be selling to these distributors, and we're going to keep doing it. And it's not just a one-person thing. This is clearly Mr. Beach, Mr. Jackson are involved on day 1, day 2, and then, of course, Mr. Jackson has this continuing plan. Let's see if there's anything else I wanted to cover. Unless this court has any questions, we would just ask that this court affirm the district court's sentence.
Thank you, counsel.
Thank you.
We'll give you a minute and a half, just so you don't get caught right in the middle of a sentence.
Thank you, Your Honor. The main thing that this court needs to find is that the findings that the trial court made were insufficient, and that is clear error and enough to essentially remand without even having to, not sending back for specific findings, because the record is complete, the government had its bite at the apple, the evidence that's there is insufficient. The court made a number of inferences in coming to its conclusion, and many of those inferences are not fully supported by the record. The evidence is not sufficient, it's not there. The court's determination was conclusory, it was too broad, and it did not lay out specifically what Mr. Jackson agreed to. The court did not also adopt the pre-sentence report, specifically the analysis. The government talks about how we can look at not only the court's oral ruling, but also the addendum, the probation officer's writings in the addendum of the PSR, that was actually not adopted. Federal Rule 32, little I3 indicates that the findings that are in a PSR do not become record absent an express ruling. The court specifically, in our case, adopts the PSR in the statement of reasons just by checking the box. But the court says specifically during the oral argument and during the sentencing hearing that the court says, now before formally adopting the PSR as my findings on all undisputed factual matters, then the court goes on to discuss other issues. The analysis that the probation officer makes in the PSR addendum is disputed, and so that was not adopted by the court, and the only thing that the court can look at is, that this court can look at is the court's oral ruling at the hearing. We ask your honors to remand for resentencing in accordance with our requests.
Thank you, counsel. Thank you both for your helpful arguments. You are excused. The case is submitted, and the court stands in recess subject to call.